Tribble in the appeal before the court this morning. And I wanted to focus on the three general arguments that we make urging this court to reverse the judgment issued by the trial court. First would be the denial of the motion for continuance that was filed by Ms. Tribble only days before the trial, and I'll get into that in greater depth. The second was the denial of the court to allow Ms. Tribble to fully explore the ability to have her defenses satisfied through the testimony of the witnesses that did appear at the trial. And then the last one basically is that in this instance, there was no issue where the appellee proved all of the necessary elements to establish that Ms. Tribble had engaged in conversion. Just by way of background, I think that obviously this court's reviewed the briefs. I would like to save 4 minutes for my rebuttal, if I may.
Sure.
This case went back to a situation where Ms. Tribble had an office building that was in foreclosure at the time. And Mr. and Mrs. Green, through their corporation, Edway, entered into a purchase of that. And Ms. Tribble basically enjoyed a lease option agreement to pay for the property as she was using it. This agreement was sometime in February of 2020. And apparently everything was okay. There was an issue regarding the insurance. That's the primary issue brought up by the appellee, Edway. But in this instance, there was a car that crashed into the building. There was a claim for the insurance, and Ms. Tribble actually had gotten that money with the intent to put that money toward the purchase of the property. At some point, the property was sold shortly thereafter, and this litigation ensued. The issues that we argued, certainly to support the argument that related to the denial of the trial court to provide Ms. Tribble with a continuance, gets down to a pretty finite area of time. And although the case had been around for several months, the real sequence of events sometime beginning in August of 2021 sort of sets the pace and I think supports our argument. Ms. Tribble hired counsel. She, even though a member of the Florida Bar, and an issue that was very important to the trial court, did not have any experience in litigating these types of cases. So she hired counsel that she thought was competent. Counsel filed an answer and counterclaim, but never participated in any discovery whatsoever. When the case was ultimately set for trial, the attorney that Ms. Tribble did hire filed a motion to withdraw. In fact, I think he even entitled it an emergency motion to withdraw that was filed on August 18th of 2021. The order granting his withdrawal was issued by the trial court on September 2nd, 2021, only several days after that. And Ms. Tribble was given only until September 10th, which was only 8 days to get new trial.
I want to just, and I just want to, go ahead, Judge Black.
Record indicating she did anything at all to try to get new counsel. I mean, counsel leaves the scene on September the 2nd. And then the next thing we hear from her is in October 12, when she's objecting to a trial date that's been set for 3 months already. But there's nothing in the record indicating, you know what? I called 4 lawyers, or I had 3 appointments, or I did what I could to try to find representation. She just basically, as I see it from the record, didn't do anything from September to October, and the trial had been set for months.
And I just want to tag something onto that. In her motion to continue, she doesn't say I need time to find counsel. And in my review of the transcript, I don't recall her ever asking for time to find counsel. It looked like she wanted to represent herself.
And when the trial first started and the judge asked if everybody was ready to go, she says, yes, I am ready to proceed.
Well, I think
I'd have a lot more sympathy if she really wanted an attorney to see some indication that she actually tried to find one.
Candidly, I think she did. There's nothing in the record to support that. But I believe the overarching, and I was going to get into this, but I'll get into it now. The overarching issue really deals with her son, who has a very severe seizure disorder. I think she made that clear, even if...
Well, I think everyone acknowledged that. I don't think that was disputed.
Right. And I think in all honesty, I think that the level of
From
numbness.
September to October, she never brought that to the attention of the court. Tried to explain how she could make some accommodations, because obviously she's a busy attorney and has this son to deal with, and not unsympathetic to it. But she didn't tell anybody about it until she filed a motion to continue.
Well, I think that she has tried to accommodate the very serious condition that her son suffers from the best she can. Candidly, I'm sure that waxes and wanes with the different periods of time. And I know that, I think it's on page 5 of our reply brief, we actually have her opening explanation to the court, where I can't say that her saying, yes, I'm ready to go to trial was knowing and intelligent, even though she did say yes. But then she gets into the specifics of her child's seizure disorder, and then says, today is a bad day. So I think in and of itself, certainly based on the history of what has happened in this case up to that point, and that being the day of trial, and obviously I agree with this court, there was time to find new counsel, but she was unable to find any new counsel. And I don't think that we articulated that. But on the day of trial, the issue is not so much, hey, I don't have counsel. It's, I'm somewhat distracted because of the seizure disorder suffered by my son.
But we still, what we need in order to review an error is that, she has to make a request and the court has to issue a ruling. And we don't really have that. And, I'm not unsympathetic to the situation she found herself in, but, it also looks like she had a chance. She only asked for 30 days when she filed her motion to continue, and opposing counsel wouldn't agree. And it looks like, to me, my review of the record, what happened is opposing counsel submitted something that was entitled agreed order, giving her 10 days and including that language as a practicing lawyer, and the court signed it. And she didn't bring it to the court's attention that I didn't agree to this.
In all honesty, I think she was so heavily distracted because it's not really developed fully in the record, but certainly the discussion of these seizures, this period of time, she was overwhelmingly distracted. And again,
and I think opposing counsel took advantage of her is what the record looks like to me. But, our hands are tied.
I understand, but I think when you get to the cases that we cite about the exercise of the court's discretion in granting a continuance, I think certainly this court is allowed to look at the totality of the circumstances.
Because we are on an abuse of discretion.
I'm sorry, Your Honor, I didn't hear you.
We're dealing with an abuse. We have to, in order to rule for you, we would have to decide that this was an abuse of discretion.
And I would agree with that. And I think that we've articulated all of the elements on that given day. I mean, clearly there's a lot of history in this case that doesn't show the highest level of diligence. But again, she's dealing with these issues. Her attorney basically files an emergency motion to withdraw. And it's not that long a period of time from August until the November trial date. She did file the motion in October and quite honestly found no new counsel. But on the day of the trial, that's one of the days that, quote, is a bad day. And I think, quite honestly, in and of itself, understanding the issues in this case, I think that should have been sufficient to establish that the court denied this motion to continue.
Well, if you're the trial court judge, what you know is that there was an agreed order, an agreement to give her 10 days. And then she never clearly asks for more time. And on this morning, she comes in and says it's a bad day, but she doesn't say, I can't do this today. I need to take my son to get medical care, or I have to be with him. I mean, there's, to find an abuse of discretion, it seems like to me she needed to be more of an advocate to get the court's attention, because all the court knows, it's got this, this agreement. Okay, continue it for 10 days. It's like you agreed to this, and you come in and you're sort of like, okay, well, I can do it, but I'm having a bad day. Well, it puts us in a difficult position to, I mean, how would we say that's an abuse of discretion with Judge Black on that? It makes it really, it puts us in a difficult position to articulate how that would be an abuse of discretion. So help us.
The help I will provide is in the transcript itself. And this is Ms. Tribble addressing the trial court that morning. I originally had asked this court for continuation. And as I explained to Mr. Levine, and everybody knows, unfortunately, my son does have not just a disability, but a very severe seizure disorder, and just randomly has seizures when we think he's okay, and not going into any way, not getting there. But today has been one of those seizure days. Anyway, I had originally asked the court for a motion. I originally filed a motion to continue. And the day that we were here, that we were set, my son had a seizure at school and I needed to take him some medicine. So I think as we go through this, in all of the events that took place before the trial court, we have an explanation as to certainly why Ms. Tribble, even though a member of the bar, but someone not experienced in this area of the law, is completely distracted by the seizure issues that her son. And to continue that, I told Mr. Bean, I haven't had time in any way, the energy to address this, but today is a bad day. You know, you have to admire anyone that tries to step up. And obviously as attorneys, we try to deal with whatever obstacles we encounter to do our best. But if you look at the totality of the circumstances, you get an attorney whose prior counsel didn't really do the job that needed to be done for this case, that immediately withdraws. And then she's left in this position during this few week period of time where he withdraws. She's given a few days to get new counsel. She indicates to the court that at the last hearing, her son had a seizure. And then the day of the trial, again, stepping up as best she could, but clearly not fully prepared. And then as she goes through the trial doing her best, and you know, obviously the issue with the continuance is the prime issue that we're arguing, but there's all kinds of evidentiary obstacles, again, you know, reflected that arguments that she never raised any affirmative defenses. No explanation for that, but she didn't prepare that answer. And now she's got no counsel and she's stuck trying to utilize the pleadings that were filed by her predecessor, so to speak, and the job just not done properly. So unfortunately, not even the best attorney is going to be able to deal with those issues on the fly. And certainly someone at that point in time that explains to the court this serious personal condition that her son suffers from and the level of distraction. I'm sure that she, in her experience, does not want to complain about this because it has been ongoing. You try to do the best you can to maintain a law practice, but you have this overarching burden that never goes away and pops up intermittently when you least expect it, certainly with no ability to foresee that this is coming. And that was one of the issues. I think we settled the Gaspar case where they talk about the different issues relative to determining whether a court has abused its discretion by not granting a continuance. This is just unforeseeable. I mean, you just never know. Not that it's, I can't say it's not repeatedly unforeseeable, but when it does arise, it is unforeseeable because there is no strict schedule. And
I want to clarify for you, because you're focusing on reasons that it was an abuse of discretion or it could have been an abuse of discretion. But the obstacle for me, the bigger hurdle for me, is that she makes no clear request. And I don't believe, my recollection is the trial court never ruled on either one of her requests. To the extent you want to argue that she made a request on the first day of trial, assuming that was actually a request for a continuance, I don't see that the trial court ruled on it. And I mean, they went forward, so I guess that's an implicit denial. But I don't think there was a ruling on the written request because this, quote, agreed order was submitted and signed by the trial court.
And I think I certainly agree the record is what the record is, but all of these bits and pieces, I think, certainly support the the extreme nature of what's happening at that point in time. The motion for continuance isn't even signed. I have to think anybody that is at their best and acting diligently as a member of the Florida bar will sign the pleadings. It's not even signed. And I don't think that reflects carelessness, because I think the issues that are brought up in there certainly explain that oversight, so to speak. But I think that, you know, the argument is made, and I think that the trial court implicitly denies that argument. There's no order on the motion to continue. That is true. And then, quite honestly, I don't even know what would have inspired any kind of order granting 10 days in light of everything that happened. But again, assuming all of that is true, assuming that she had done the perfect job up to that point on the day of trial, to be subject to that level of frustration, that level of distraction, and having dealt with all of these issues throughout this case, and certainly throughout the last several weeks, to reach the crescendo of, quote, a bad day. I mean, I'm sure that's an understatement, but I don't think anybody wants to, I guess the best way to say it is everybody tries to deal with their obstacles privately. Sometimes we have to overcome those in the practice of law, and sometimes we have to actually explain those fuller. But I get the impression that Ms. Tribble is really just trying to cover for the fact that she's burdened with this repeating issue with her son. And quite honestly, I'm sure it's had many, many issues along the way, but today was the day that she had asked for more time. The court didn't grant it, so she stepped up and did her best, and could accomplish next to nothing, because the court upheld most of the objections with the testimony. That, again, this is kind of dovetailing into the second component of our argument, but she should have been allowed to explore her defenses more fully. She had no affirmative.
You are at your rebuttal time. You can proceed as you wish.
I will go ahead and save the rest for rebuttal, and thank you for the privilege.
Hey, Mr. Grave, you're up. You're muted.
Thank you. I apologize. Yeah, may it please the court. My name is Heather DeGrave on behalf of the appellee Edway Inc. And this court should affirm the final judgment of the trial court. Since most of the argument was taken up with the motion to continue, I'll start with that. The trial court acted within its discretion in denying appellant's written motion to continue the trial. And as Judge Kelly noted, there wasn't really a clear request to continue the trial on the morning of trial. Specifically, the appellant said, "I'm not going there," with respect to her son's condition. And all that was said was, I would like to take him some medication. That doesn't indicate the need to continue the trial to another day. And there certainly was no clear request and no ruling on that request. With respect to the trial being scheduled, the trial was scheduled by agreement of counsel for the parties, and a uniform order scheduling trial was issued accordingly. And there was no objection to the trial date or suggestion of unavailability until only a couple of weeks before. The appellant waited over a month after her counsel withdrew, and only a couple of weeks before the scheduled trial, to seek a continuance. With respect to the withdrawal of her counsel and the order directing her to obtain new counsel, the reality is that there was no indication that there was no motion for extension of time to retain new counsel, and there's no indication that she ever did. That there was no counsel who filed and said, "I realize that I'm past the deadline, but I would like to appear." You don't see any of that. So the idea that that this agreed order put this undue burden on her just isn't supported by the record.
Why? It's styled an agreed order, but she had asked for 30 days, and that order says 10. It seems like to me there's a difference there between 10 and 30.
Yes, Your Honor, frankly, although I'm part of that firm, I don't know the specifics of what happened. I was not involved at the trial level, but I do know from the record that all parties agreed, all individuals involved agreed to Mr. Hannon's withdrawal as counsel, and so to the extent
right. So everyone agreed to that, And the only difference between the parties was she wanted 30 days and you all insisted on 10. You wouldn't give her that extra 20 days.
Right.
So that necessitated her former counsel of filing an emergency motion to get that resolved. And then all of a sudden this agreed order for 10 days pops up.
Yes, Your Honor, and I can't speak to why it's called an agreed order if there was a disagreement as to the number of days. I can't speak to that. So I apologize to Your Honor, but I can't speak to that. I don't know the facts behind that.
I understand.
But the reality is, you know, that had she retained counsel after the fact, after the September 10th deadline, and had they appeared, there really wouldn't have been any valid basis to reject that attorney's appearing. I mean, you know, constitutionally, she has the right to be represented by counsel. So I think that to the extent that it's called an agreed order, I think that it's harmless in that regard. But then she waited an additional month to say that she hadn't gotten new counsel, and you know, and to seek to continue the trial. And there was nothing in the motion to continue that would have given enough specifics for the court to rule on the motion to continue. I will say that there was an order entered.
No, the motion to continue listed all sorts of things that she wanted to do. She wanted to do discovery. She wanted to amend the answer and affirmative defenses. I mean, she set out a laundry list of things that former counsel did not do that she wanted to do. And so I wouldn't say it didn't contain any specifics.
Well, but it didn't contain specifics in terms of how, you know, with respect to her son's condition, when there would be availability, when that issue would be resolved. And then with respect to her suggesting that she would like to do discovery and would like to seek leave to amend, she didn't actually do any of that. And she had the capability of doing that herself as a pro se defendant, and even more importantly, as someone who herself is a litigator. She could have filed a motion to amend. She could have pursued discovery, and she never did.
Well, her motion seems to indicate she plans to do it. She doesn't say anything about retaining counsel in the motion, is my recollection. Right.
And so to that point, she says she plans to do it, but then she never actually does it, even after there is an order.
Paragraph 6 of her motion to continue really doesn't make any sense. It says the defendant has been unable to thoroughly review the case and filings. The defendant has a chronically ill child that limits defendants, and then that's it. The sentence stops.
Right. And I guess it could be implied that she meant her ability to review the pleadings and prepare motions for amendment.
Talk about the things that she.
I'm sorry, Your Honor, I couldn't hear you.
After that chopped off sentence, she does lay out a couple of things that she intended to do, which ended up not getting done. She anticipates filing a motion for leave to amend answer and defenses, review the filings of the preceding discharged attorney, but I don't see where that was ever done. Any of those were ever done.
Right. I don't see that any of those planned actions were ever done, and they could have been done by her, or she could have retained counsel in those 2 weeks and it could have been done by them, or at the very least that counsel could have filed a renewed motion to continue and identify those issues. That just did not happen. And the motion itself is insufficient, procedurally insufficient under the rules of civil procedure, rule 1.460. It was unsigned. She doesn't actually give any record evidence regarding the situation with her child, doesn't provide any documentation to support it. And at trial, she says that someday—
You're not disputing that her son has the special condition, right? You're not disputing that, are you?
Right. I mean,
it seems like everyone knew that.
Right. I don't think we have any facts to suggest that she.
So even though everyone knew it, she should put all this evidence in her motion.
Well, I think that she should definitely explain why it prevents her from— I think that there should be sufficient documentation to explain why it prevents her from being able to proceed with trial on the day of.
She's an officer of the court, and she says, I've been busy with his condition and I haven't been able to do these things.
Yes, that's fair, but it's not sufficient in order for the court to rule on it. For one thing, you know, what she's saying is, what she said at trial was, some days her son has a bad day, and while I think we're all sympathetic to her situation, you know, trial courts can't function like this, where if someone shows up on the day of trial and says her son's having a bad day, that we have to continue despite all the preparation that all of the parties may have had ahead of time, despite the preparation that the court may have had ahead of time. So these sorts of vague statements like that just don't give enough information for a court to properly rule. And at trial, she did not actually clearly say, I need a continuance today, and this is what I need a continuance for, and this is how long I expect it to be. That just didn't happen. And she proceeded with trial. So it was within the court's discretion.
I'm not sure where you are in your time. I'm sorry. I know we spent a lot of time on the continuance issue, but I'd like you to.
Mr. Grave is 8.5 minutes in, so she has.
Oh, okay. Well, before you wrap up, I would like to hear what you have to say about the conversion issue.
Yes. So, yes, Your Honor, I'll move to that now. There was substantial competent evidence that supported every finding of the trial court, and specifically with respect to proving a cause of action for conversion. And the evidence was, in the most part, uncontroverted. The appellee demonstrated with substantial competent evidence that appellee had a clear and exclusive legal right to the insurance proceeds for damage to the property. That's paragraph 7 of the commercial lease and option agreement.
I wanted to ask you, I'm glad you brought that up, and I'm not sure if this is actually raised in the appeal, but paragraph 7 segregates the casualty insurance from, the property insurance from the casualty insurance, and doesn't contain the same requirement for naming the owner as an additional insured. But yet you all relied on paragraph 7. How does that work?
Yes, I'm looking at paragraph 7 right now. It is lengthy.
Yeah.
Well, and the final paragraph that's cited in the answer brief at page 9 talks about, if pursuant to subparagraph A and B above, landlord, that would be appellee, elects to restore and rebuild, or is required to restore and rebuild, the landlord will do so at its sole cost and expense, but will have full use and availability of the proceeds of any insurance that has been provided and maintained by either landlord or tenant, the proceeds of which are payable in the event of a fire or other casualty. So that's exactly the facts that we have here. We have that there was this casualty that resulted in significant damage to the building, and that there was a policy in place that provided insurance proceeds, and the evidence was uncontroverted that the proceeds were specifically for property damage, for repairing property damage to the building. That the Naomi Brunn testified that the estimate that was used to make that amount was specifically for property damage to the building.
The allegation was that she should have named the landlord as a lost payee.
Yes.
But what it says is the tenant shall maintain insurance in an amount not less than $100,000 for property damage loss from any one accident or occurrence. And unlike the preceding sentence, it doesn't require anything in terms of naming the landlord, which I think is why you relied on a bunch of emails to prove that, maybe.
Yeah. Yes, and there was substantial evidence with respect to the lease negotiations between Mr. Young and Ms. Tribble, where that when he included paragraph 7, appellant knew and understood that appellant was obligated to name appellee as the lost payee for the property casualty and commercial.
Whatever they negotiated is one thing, but the contract says what it says.
Yes, the contract says what it says, and the contract says that with respect to a loss as a result of casualty, that if the landlord is going to restore and rebuild, that they have the full use and availability of the proceeds of that insurance. So it's right there in the contract, and that there's just with respect to the emails back and forth, it just shows that that appellant had no question about this, that she knew that these proceeds belonged to my client, Edway Inc.
So she wasn't entitled to rely on the written document?
Well, but I guess the written document clearly says that that these proceeds are payable to the landlord for repair as a result of casualty. And what we see is that she is by her actions assuring Edway through its representative that she is going to add appellee as an additional assured and as a loss payee, and then she never actually does, and she should not be rewarded for that conduct. The most important evidence that the insurance proceeds are the property of the landlord is that after rebuilding, the landlord is entitled to retain any surplus. So so not only are they entitled to the proceeds, but even if those proceeds result in a surplus, they're entitled to retain the surplus.
What about the testimony of the representative of the insurance company saying they would never have made a payment to the landlord only? Doesn't that indicate that at least the insurance company thought she had some insurable interest also?
Well, no, I think that the point of the testimony was that they never would have made a payment just to her if they had known that there was this other person with an interest, that is Edway Inc. The idea is that...
But am I misremembering that the testimony also was we would never have made a payment just to the landlord only?
I don't recall that testimony. What I recall is that they said they would have issued a joint check, but the reality is that she was the policyholder. So it only makes sense that she would have been included in the joint check. But what they were specifically saying was that it would have been a joint check. It wouldn't have been a check to Ms. Tribble only if they had known, if she had not represented to them that she was the owner of this property, or that her law firm was the owner of this property. That had she properly represented that my client was the owner of the property, they would never have issued a payment just to her. That was the gist of that testimony. And there was a specific identifiable sum of money, that is the check in the amount of $116,000. And the testimony by Naomi Brunn that was based on the estimate for the repair of damages to the building. And it was uncontroverted that appellant had directed the insurer to send a check to her only, thereby depriving Edway of the use of the funds in contradiction to the provisions of paragraph 7, and that the appellee, Edway, demanded a return of the funds, which appellant refused. And then at trial, appellant could not account for the balance of the insurance proceeds. So in terms of each element of conversion, there was substantial competent evidence that supported each element of conversion. And so therefore the trial court should affirm on that ground, or the appellate court should affirm the trial court on that ground.
Did she offer to pay down the loan? I know they weren't calling it a loan, but did she offer to use the proceeds to reduce what she owed?
Right. So I know that she raised that at the trial, but there was no evidence that supported that vague statement that she made at trial. There was no evidence that she offered to pay down the loan, or that she had ever reached out to my client and said, hey, why don't I take this money and use it as the down payment to purchase the building back from you. That just wasn't, although that's something that she said at trial, there was no evidence to that effect. And to Your Honor's question, I think another element of Your Honor's question about the insurable interest is that was an affirmative defense that wasn't pleaded. And although that the trial court
she denied, but she did deny the allegations in the complaint. So you haven't, which means that the allegation that the landlord was 100% entitled to this money was denied. So you got to prove that.
Right.
Regardless of her affirmative defense. Isn't that right?
Well, I guess if you, you know, I guess it's a question of what is an affirmative defense. If and I think that specifically saying, well, no, actually, I had this insurable interest because I had an option in the lease, goes beyond a mere denial and becomes an affirmative defense that she had the burden to prove. And in any event, the trial court actually, in the final judgment, addressed these defenses, even while at the same time finding that they had not been properly pleaded. If you look at pages 6 through 8 of the final judgment, paragraphs 31 through 35, specifically addresses on the merits the argument about an insurable interest, about there being, you know, that it was not a valid defense because there was a naked option in the lease agreement. Pages 8 through 9, paragraphs 36 through 39 of the final judgment addresses her argument that that she had personal property that she had lost, and that's just not supported by the record and by the facts with respect to the basis for the $116,000 check. So any refusal to consider those as affirmative defenses was harmless because they were actually considered in the court in the final judgment. And the reality is that that she never actually did assert those affirmative defenses. Even though she said she intended to, she never actually did. Litigation is framed by the pleadings, and a court actually abuses its discretion in considering issues outside the scope of the pleadings. So it was proper for appellee to object to the testimony related to the unpleaded affirmative defenses, and it was proper for the trial court to sustain the objections. So, Your Honor, unless there are any further questions, I'll conclude by asking that the court affirm the final judgment of the trial court.
Thank you, Mr. Grave. Mr. Leroux, you're up for rebuttal.
Hey, please, court. So the issue here really, it gets down to the fact that both parties submitted proposed final judgments. And the issue that we raised in our briefs was that the trial court would not allow Ms. Tribble to explore those issues through testimony. They found their way into that final judgment through the inclusion of those issues by the appellee, by Edway. They put it in there, even though the trial court precluded Ms. Tribble from getting into any of those issues during the trial. And obviously you've read the transcript. You can see that, you know, even though she had filed a general denial counterclaim and had really, from my perspective, sufficiently brought those issues before the court, the argument was that because she didn't specifically identify those as affirmative defenses, that she couldn't get into them. The trial court agreed with that. And then when the final judgment is entered, all of those issues that she couldn't get into in any depth all found their way into that final order. I would certainly agree that the contract says what it says. I would certainly say that if Ms. Tribble indicated that at some point she was going to take that money to put toward the lease option in the property that she believed she had sufficient and substantial equity in, that's certainly appropriate. And I would certainly agree with the observation that when the insurance company, when Ms. Brune talks about this, she said she would never issue any check singularly to the landlord, that it was going to be a joint check no matter what. It was not going to go singularly to the landlord no matter what had happened in this. So as far as the conversion, I would suggest that there's no intent to do anything. And the one element that's missing from this explanation is that Edway sold this building around that point in time and made substantially more money than anything that's at issue in this particular matter. So quite honestly, and again, I hate to talk about these generalities, but we all as human beings have to look at the environment in which things are done. The level of desperation that is evident in everything that Ms. Tribble had been doing through this period of time, I think is a sincere reflection of the actual exigencies, the unforeseen exigencies that she was dealing with. And quite honestly, I know that there's a struggle on her part that I think is also attributable to a level of discomfort, a lack of being fully prepared, a lack of being fully competent to go forward, but begrudgingly just doing this because quite honestly, it would appear that she's had enough. She's beaten down by the combination of everything that she's faced in this case. And not to beat a dead horse, this prior attorney who did next to nothing makes a run for it literally on the eve of trial. Then, you know, even though it says it's an agreed order, I think the plausible explanation is that she wanted 30 days and then it comes up to 10 days. I would suggest that she would not have agreed to the 10 days. I'm just going to assume that might have been some remnant of word processing that got lost. We'll never know, but I think the indication is Ms. Tribble would not have agreed to 10 days under these circumstances. And quite honestly, there is a lot of discovery. I mean, the case was just not litigated properly well before Ms. Tribble got involved. And then after she got involved, and again, I focus again on this desperate motion to continue, she is going to do her best. Doesn't have new counsel, but she's going to try to amend the complaint. She's going to try to get some discovery. And quite honestly, you know, the argument that, well, she never did anything. If you put this in perspective with the dates, the motion to continue is on 10/12, the trial's on 11/3. If she had done all of that, there would never have been enough time for any discovery to be responded to. Those time periods are well within the 30 days that a party has to respond to interrogatories, requests for admissions. Any kind of discovery that she would have undertaken would never have been completed by the trial date. So in spite of the fact that she had done her best, I think certainly, and I heard this court use the term before about the benevolence to litigants. I understand that there's very serious issues that have to be established in the record of any case in order to support a request that there be a reversal, especially to establish an abuse of discretion. But I would respectfully submit that if you look at the totality of these circumstances, what Ms. Tribble was able to explain when she was able to explain it, in the interest of fair play, substantial justice, and everything else that we all have dedicated and taken oaths to protect, I would respectfully request that this court reverse this final judgment and give Ms. Tribble a full opportunity to do the job that needs to be done so that all of the issues that she wanted to raise, hoped to raise, and probably would have, but for all of the different obstacles that we see repeatedly, time after time after time, obstacle after obstacle, I would respectfully request this court reverse this matter and remand it so that we can have a full and fair trial on these issues. And I'm very grateful for the privilege, and I'm happy to answer any additional questions that the court may have.
Doesn't look like it. Thank you much, Mr. LaRoe.
Thank you very much for the privilege.
Guys, to leave, you need to click the leave button on the Zoom screen and you'll be gone.
Thank you very much,
You
Your
will.
Honor.
You both. Okay, the court will be in recess for 10 minutes.